Welcome again. Welcome again to A Taste of Justice with Professor Angela Mae Kupenda. I'm a law professor at Mississippi College School of Law, but I tell you the name of my school only for identification purposes. All views expressed here are my own and not to be ascribed to my school or my students. So let's get with it. We've been talking about a taste of justice and how having a deeper understanding of the Constitution is so essential. It's essential for us to have delivery of the undelivered constitutional promises that you can read about in the preamble of the Constitution. And also this series is for the students currently enrolled in my classes to give them a little taste before they do that lengthy reading assignment and to give them a little review after we meet together remotely in class. Now, the topic that I want to talk to you about today is what you talking about, government? Oh yeah, what you talking about, government? Or rather, we're looking at how the courts scrutinize governmental action. If you haven't looked at the earlier clips about state action, make sure you go back and take a look at those in the introductory series. So I always hear people saying, the government did this, what the government did was wrong, I ought to sue them. Okay, so you're going to sue the government because you believe that something they did was wrong. And as a result, the case will go to court, likely to federal court if it's about a constitutional issue. That's likely where it will end up. And you're going to be asking the court to review or to scrutinize what government did. Now, don't get it twisted here. The court has held that ordinarily what government does not have to be wise, that it can even be silly. I'm not making this up at all. Ordinarily, governmental action is scrutinized by the court, not at a high level, but at a low level called rational basis. Rational, R-A-T-I-O-N-A-L, basis level of review. There is a presumption that what government is doing is rational. Rational basis, this low level of review, only means that government's actions must be rationally related to a legitimate governmental interest. So the government must have a legitimate governmental interest, and its actions just have to be rationally related. It's sort of a reasonableness test. Now, and that's the general rule. But sometimes the court says, what you're talking about, government. Now, that may sound familiar to you. I used to watch this sitcom. I don't know if you've ever seen it. From years ago, it was called Different Strokes. And Different Strokes was about two little black boys, Arnold and Willis. They were adopted by a white family. And little Arnold, he really was a cut up. Sometimes when his brother or his father gave him various instructions or something he just didn't understand or didn't appreciate, he would look at them and say, what you talking about, Willis? Or what you talking about, Mr. Drummond? Now, sometimes the court does not use the low level of review, or rather it says, what you talking about, government. Now, That's not what the court calls the test. That's just what I call it, okay? Now, there was this case going way back. It was actually about milk, but this case is called Caroline Products. In a footnote 4, at the bottom of this video in the text, make sure you read that text. You can learn an awful lot, not just from the video, but from reading what I've typed out for you. Caroline Products footnote 4. One of the justices in a footnote says this. He says that sometimes we have to scrutinize government more, not the low level, but a heightened level. What you talking about, government? Sometimes we scrutinize government more if they are taking steps that infringes on certain individual or fundamental rights, or if government is taking some actions that are directed at religious minorities or racial minorities or other groups that do not have the majority power to facilitate change, perhaps at the polling booth or in the election of governmental officials. So the court says sometimes we got to say what you're talking about, government, when our fundamental rights are at stake, or if government is taking action directed at racial minorities, religious minorities, etc. Now, Caroline Products, footnote 4, the most celebrated footnote in constitutional history. Now, I like footnotes. You may not like footnotes. Some of you've done footnotes with papers, what have you, or articles, but I like them. So this justice sneaked that comment in. Ultimately, then, we come to several levels of review. We have this low level, let me let you see it, low level, rational basis. All government has to show that is rationally related to a legitimate governmental interest. It's a presumption that what government is doing is valid. But that presumption, of course, can be rebutted because government may not even meet that low-level test. But on some things, the court says you use heightened review. Here's rational, heightened over rational. Now, the highest level of review is called strict scrutiny, S-T-R-I-C-T. Strict, we're looking at government strictly, right? That level of review, government must establish a compelling governmental interest, and the government's action must be narrowly tailored to that interest. In other words, what you're talking about, government, why are you doing that? When we use that heightened level, there's a presumption that what government is doing is invalid, but government might still meet that test. So let me just give you a little practice exercise. Look, I got these notes and everything. Usually I don't have notes, but I wanted to stay on point. Okay, let me give you an example. Let's say, and nowadays we hear a lot of people arguing about their privacy rights and bodily integrity and so forth. Before I give you the example though, let me just point out to you that even if there is such a fundamental right, according to the court, no right is absolute. Even if you use the heightened level of review, government might still be able to satisfy it. And of course, a low level of review, sometimes the court says, government, you didn't even meet that. But I digress. Let's get back. Let's say there's this situation. Let's say there's this situation where it occurred in Oklahoma. And the state of Oklahoma said, look, we want to stop some of this criminality, okay? We want to stop some of this criminality. We have all of these people in jail. We need to stop. And so the state says, you know what? The state figured that individuals who engaged in criminal behavior would automatically have children who engaged in criminal behavior. So the state said, for individuals who are engaged in certain criminal behavior and are convicted, not only must they serve out their sentence, but they also must be sterilized, because they said one criminal is enough. We're going to sterilize them so they will not be able to have children, because the government of Oklahoma was concerned that the children would also commit criminal actions. Now, there was one little twist. There was a twist, an additional twist in what Oklahoma did. They said, well, you know, we don't want to sterilize embezzlers. If you embezzle money, even if it's a large amount of money, we're not going to sterilize you. But if you're a chicken thief, if you've stolen chickens, or done some other things of that nature, we're going to sterilize you. So government said the low level of review applies. Here, what the government argued, what they were doing was rational to cut down on criminality. And under a rational basis, a law doesn't have to be address every single nuance. So Oklahoma said, we're good. What we did is constitutional. We're going to sterilize this chicken thief. But the court said, hold up a minute. Hold up. Take a look at Caroline Products. Take a look at that footnote 4 in Caroline Products. The court said, this is a matter of bodily integrity, of procreative ability. The government can't just go around sterilizing certain groups of individuals, even if they are convicted. That's a separate type of fundamental type of right related to your ability to procreate. So the court said in that case, they're going to go with what? Heightened analysis, because the court said, what you're talking about, government, right? And so therefore, the court employed strict scrutiny. Does government have a compelling governmental interest? And is what government is doing narrowly tailored to that interest? And the court held that it was not. So here, Caroline Products footnote 4, and also Skinner versus Oklahoma noted below, will give you examples. Now, rational basis low, strict scrutiny heightened. Of course, this is the law. There's another level in the middle, but we'll come back to that when we address equal protection related to gender. And you'll see that it gets even more interesting than before. Now, that's the only point I wanted to make right now. The next clips will take us on into looking at privacy rights and what we just said about the levels of review. Will it be a low-level rational basis or a heightened level, strict? That's going to be very relevant, especially in closed cases. If the government is, if the court is closely scrutinizing government, then likely, not always, but likely the law will be held unconstitutional. But if the government is using if the court is using a low level of review, then likely there's a presumption that what the government is doing, although it may be silly, according to the court, it may still be determined to be valid. So we will be applying these principles, okay? Again, this is a taste of justice with Professor Angela Mae Kupenda. Now you make sure you subscribe and you sign up for notifications. There will be topics this semester on common law, but also topics on my other course, Civil Rights Lawsuits, Section 1983. Okay, so you watch for the forthcoming videotape that's going to cover privacy rights. There will be privacy rights take 1 and privacy rights take 2. Thank you, and you have a great day. Okay, I have to shut this down. Bye.